needs. So tell us, Claudia, a bit about the conclusions that your breakout session reached.
Okay, thank you very much. Well, for those of you that were not here, I think it's important to flag that we were indeed exploring with experts working across the fields of craft, design, plant variety protection, geographical indications, and law enforcement. What are indeed the main challenges? What are indeed the main gaps? It's been a very truly interesting discussion. And even if we have differences on the nature of each of these different IP rights, because as it was very well explained, designs have actually their own IP framework, and we see it also from geographical indications, which also have specific requirements that need to be tested, also from the enforcement perspective, I mean, related to their names, links with the products, their product specifications, etc. And then the plant variety rights, which also have their own specificities when it comes to, the protection that is granted to plants, to seeds. We were hearing examples of pepper with spicy, with onions that do not make you cry. I mean, this type of plant variety rights that would be covering these specificities of varieties. So each of them play actually a very critical role, and particularly of interest for the creative, cultural, and agricultural sectors. I think what it is also important was, I think there is a clear, message that enforcement efforts are still, lagging quite behind, also in comparison to trademarks and patents. And I would highlight, at least, I would take three main challenges that have been identified. So the first one, and I think it's important to frame that many of the speakers were identifying the actors that are holding these rights as SMEs, and even solo, one artist, one farmer, one breeder. So that we're really talking about big, important sectors, but for very small players. And I think that is an important message to take away. And what it, translated is, first of all, that enforcement is too complex for these small and medium enterprises. It's too complex, it's too expensive, it's too lengthy, and that actually there is a need for more guidance. It's a need for more awareness. And I think that was one of the clear messages as well in terms of challenges, not only for designs, where that was also a very clear message. Designers are often not aware of what IP can actually bring them for them and how to actually protect their designs. But also for plant varieties rights, a big méconnaissement, as we say in French. So it's a right that needs a lot of attention because it's not so well known. And including also, of course, for GIs. So a lot of calls for additional awareness campaigns. Then when it comes to other challenges that have been identified, I would say as well this lack of confidence that if you engage into litigation, for example, to protect these rights, you will not have enough compensation that will also actually lead you to, engage in these what is considered lengthy processes. Finally, I would also highlight in terms of challenges, and it was mentioned particularly for crafts, the fact that many of holders, potential, actors, do only react, but they don't prevent IP infringements. And that is, I think, a very important message to take away. Now, we were looking also at possible solutions. And what is, that it is that it is being, made available currently. And I heard, for example, from the Danish association, the fact that there is in a dispute settlement panel being set up in Denmark, which is intending to facilitate for those right holders the ability of testing their claims before actually they commit to litigation. Obviously, it all relates to cost, and it's perceived as also often going to litigation is costly. But this very much links to the recommendation that the Commission had adopted last year as well, which is recommending the use of dispute settlement solutions. We have also been discussing the challenges raised by the digital sales of counterfeit plant seeds, products, crafts, and one of the elements that was raised, particularly for plant varieties, is the fact that there is more and more sales of seeds in small parcels coming from third countries, being imported into the Union, that no one is really enforcing, no one is really checking, and that because consumers are also sometimes not aware, it becomes more and more challenging for marketplaces actually having an important role, and obviously the customs and the enforcement authorities there. And how that increased online challenge can be addressed. That was also one of the discussions, again, raising awareness. But most important also as one of the solutions that were brought also for AI, develop designs, for example, or for designs which are just traditionally made, but might be going beyond the traditional just physical feature, being part of a systemic, for example, solution as part of a design, is to ensure, well, first of all, the remuneration. I think that was certainly an element that I'm sure my colleague Emmanuel will also discuss in the copyright table, but remuneration of designers, how to ensure that, and possibly a solution is also the use of new technologies like blockchain, so developing solutions that can allow from A to Z evident the creation of that designer or that producer, so that can actually be evidence in case of infringements. Now, I could maybe also just finish by highlighting also that from the enforcement perspective, I think one of the also takeaways is that for this type of rights, to enforce them, you actually need specific capacities, technical, and obviously even test and DNA laboratories that could then help the enforcers identify the source of that illicit product. And so strong cooperation, again, with the right holders is certainly one of the paths that we were hearing from our Italian Guardia di Finanza representative. So more training, more capacity to engage with the right holders, and more awareness as well. And with that, I think I've passed most of the messages we've heard. Thanks.
Thanks, Claudia. I think that's a particularly important message that you noted about being more reactive than proactive when it comes to IP rights, that a lot of times, I think particularly SMEs, they don't get involved in this until an infraction has occurred, until they notice some kind of violation, rather than pursuing a proactive strategy. And there's all kinds of reasons for that. As we discussed on the previous panel, costs, number one reason that makes this difficult for small companies. But even for larger companies, it could be tempting to, I think, put the proactive strategy on the sidelines. And then also, as you noted, I think a theme that's come up a lot over the past 2 days is that enforcement is too complex, but also too fragmented in a global world where we're really looking at an e-commerce system that's crossing borders. So thanks so much, Claudia, for that summary. Emmanuel, let's turn to you next. So your breakout session was dealing with a subject that has come up over and over the past 2 days, which is generative AI. I think we've talked about how AI presents opportunities and challenges. I think when people in this room are thinking about the challenges, they are thinking about generative AI because there's all kinds of concerns about IP infractions in terms of where the AI is getting all of the things that it uses to generate the generative AI, whether it be text or through images. So tell us a little bit about what you talked about in your breakout session.
Yes, thank you.
Just want to flip up the, there you go.
Thanks. So yes, in our breakout session, we really had a very interesting and practical discussion, mainly focused on the challenges that generative AI poses to copyright content made available online. So we discussed the challenges from the point of view of the right holders, with a focus on news media and the impact on press publishers. And we also discussed, the strategies which are developed both by the right holders and the AI developers, with panelists representing OpenAI. And we also engaged in a discussion on possible solution. So to sum up a bit the discussion on the challenges, you mentioned the problem of the injection of copyright in the training of the AI model. This was clearly mentioned as a key issue by the right holders, the press publishers, but we also touched upon the possible copyright infringement in the output, which is generated by the AI application, in particular where you have AI-powered search engines, which can already give summaries or information about press article, for example, and in this case, which come in direct competition with the press publishers and also divert the traffic and could have an impact on the advertising revenues. So we had this strong concern expressed, by the representative of press publishers in terms of challenges, and also information about the action that are already taken by the right holders, because they are aware of this risk of massive copyright infringement. It's not about, identifying individual infringement, but something a bit more at scale. And for this, the right holders are already taking action to reserve their right. We have, an exception for text and data mining under the EU legal framework, which allow to do text and data mining of a copyright protected content unless there is a reservation of right. So the right holders who do not want their content to be used under this exception have to take action to express this opt-out, and this is being done in practice in many different ways. And there are also action being taken by the right holders to try to negotiate licensing agreement with AI providers. However, the scale and the scope of this license is, for now, quite limited, and it concerns mainly, big media publishers, but not the long tail of all the sector. And of course, the last possible action that the right holders can take is legal action and really, bringing a case to a court for copyright infringement. But this is seen as costly and as really, the last resort action that can be taken, and that is also very difficult to take without transparency on the content which has been used on the training. On the other side, of course, we had, and this made the discussion also very interesting, the perspective of the AI developers, explaining also all the action taken up front to create some due diligence in the use of the content for the training of the model. So there is already, some action being taken to respect, for example, the reservation of right expressed by the right holders, with a particular reference to the robots.txt protocol, which is a widely used standard, although it has also been mentioned that, it is not functioning perfectly well for the purpose of expressing the reservation of right under the TDM exception. Other action taken by the AI providers that were mentioned in the discussion included also the blacklisting of certain illegal websites that should not be used in the training of the AI model, and also some checks made on the use of third-party data sets which are used in the training. Then, of course, action are also taken at the output side to mitigate the risk of infringement in the output. And this was well explained during the panel. We had also a very interesting perspective brought by speakers representing member state and the EUIPO on the role of national and EU level bodies to support this enforcement of rights. And there was a reference to the discussion that took place during the Hungarian presidency last year in the Copyright Council Working Party, where there was a broad discussion between member states on the challenges raised by generative AI. And the main outcome of this discussion was that member states are not necessarily all calling for one single solution or one strong legal intervention in this area, but they have expressed a number of concerns on the lack of clarity of the existing rules and the difficulties for the right holders to enforce their right in the current regulatory landscape. We also discussed the study that was recently published by the EUIPO on the development of generative AI from a copyright perspective, which is a very broad study including a lot of legal, technical information about this interplay between AI and copyright. And this study has been really helpful to bring some rationality in this debate, which is often very passionate, by bringing information, for example, on the existing solution for the reservation of rights. There are other solutions that robots.txt, and they can work, they are being used. So this is, for example, one of the important findings of the study, but also interesting finding regarding licensing and regarding also the role of public authorities. Now looking a bit at the solution, this is also what we discussed in the breakout session. Of course, from the right holder's perspective, there is a need for better respect of the opt-out expressed by the right holders, stronger transparency on the content used in the training, but also on the crawlers which are used in the TDM process and in the AI training model. And in addition, also a call for stronger enforcement measures and for changes to the existing legal framework in order to introduce or to remove the safe harbor that AI providers can benefit currently under the existing rule according to the right holder, in order to have stronger rules which can make it easier for the right holders to enforce their rights. On the AI provider side, the perspective was rather on market-based solution, so how licensing and even more broadly partnership, we discussed this distinction between licensing agreement and partnership, which bring a kind of win-win solution when there is the AI providers also bringing some new technological tools to the right holders in order to better exploit their content, and at the same time use the content of the right holders for the training, but also for the display of the content online. And finally, we also discussed the role of national authority and the role of the EUIPO in all this future scenario of better enforcement, with, for example, national authorities having a role in terms of helping the right holders to prevent the infringement, but this requires also understanding the technicalities of how GenAI works and how it affects the exercise of the right, and a possible role also for the national authorities to raise awareness about the existing challenges and the existing technical and regulatory solution. And finally, the EUIPO also mentioned the possible role that they could play, in particular the Observatory of IPR infringement, in terms of raising awareness and providing technical assistance in this area, with the upcoming launch of the Copyright Knowledge Center that the EUIPO will do at the end of the year.
Great, thanks a lot, Emmanuel. I think what's striking there is that obviously it takes a lot of money to try to pursue these things that we were talking about before, and without the transparency in terms of the scraping of the AI systems, the due diligence that's required to actually be able to find proof that your IP was used in the generative AI is so expensive at the moment, because without the transparency, that I'm sure it would discourage a lot of companies. So it'll be interesting to see how that evolves. Well, thank you to both of you for some excellent summaries and for your excellent chairing of the breakout sessions. A round of applause for Claudia and Emmanuel.